You've finalized your separation agreement or received a court order. Your child support and spousal support arrangements are in place, and it feels like a huge weight has been lifted. Then a few years pass. Maybe your former partner receives a significant promotion. Maybe your income changes dramatically. Maybe your child's needs evolve as they grow older. Suddenly, the support arrangements that once seemed fair no longer reflect your reality. This situation is more common than many people realize. I'm Deepa Taylor, founder of Taylor Law Professional Corporation, and today we're talking about when it may be time to review and update child support or spousal support arrangements in Ontario. Many people assume that once support is established, it remains fixed forever. In reality, family law recognizes that life changes. The key concept is what Ontario family law refers to as a material change in circumstances. A material change is a significant change that would likely have affected the original support calculation if it had existed at the time the agreement or order was made. Support arrangements are based on a specific set of facts at a particular point in time. When those facts change significantly, it may be appropriate to review the support arrangement. Let's start with child support. Child support is generally determined using the child support guidelines and is heavily influenced by income. One of the most common reasons to review child support is a significant increase or decrease in either parent's income. If one parent receives a substantial raise, changes careers, loses employment, or experiences another major financial shift, the amount of child support may need to be adjusted. Changes in parenting arrangements can also justify a review. For example, if parenting time changes significantly, or a child begins spending substantially more time with one parent, the support arrangement may need to reflect that new reality. A child's needs can also change over time. As children grow older, expenses related to education, extracurricular activities, healthcare, childcare, or post-secondary education may increase. These changes may affect both basic child support and special or extraordinary expenses under the child support guidelines. Spousal support may also require review when significant life changes occur. Examples include a substantial increase or decrease in income, retirement, disability, serious illness, job loss, or major changes in financial circumstances. In some situations, the person receiving support may become financially self-sufficient, while in others, unexpected challenges may increase their financial need. The specific language contained in a separation agreement or court order is also important. Some agreements include review clauses that specify when and how support should be reconsidered. Others may contain conditions that automatically trigger a review if certain events occur. One question people often ask is whether every income change qualifies as a material change. The answer is no. Minor fluctuations in income generally do not justify a formal review. The change must be significant enough to meaningfully affect the fairness of the current support arrangement. Another common question is whether support can be changed by agreement. In many cases, yes. If both parties agree, they may be able to update support arrangements without lengthy court proceedings. When an agreement cannot be reached, it may be necessary to seek a variation through the court process. The most important thing to remember is that support arrangements are intended to remain fair and reflect current circumstances. They are not meant to stay frozen when life changes dramatically. If your financial situation, your child's needs, or your family circumstances have changed significantly since your original agreement or court order, it may be time to review your support arrangements. Understanding your rights and responsibilities can help ensure that support remains appropriate, fair, and aligned with your family's current reality. Contact us if you have any inquiries regarding Ontario family law.